Okay, Senator Ruane, go ahead.
Thank you, Laska Hirlock, and thank you, Minister, for your time this afternoon. So this amendment, obviously, I support the principles of this bill, especially in relation to diversity and diversity. Formally move the amendment. But nowhere within the bill, I suppose, does it actually define what diversity actually is. It more looks like a diversity of sectors of different professions, more so than of society as a whole. So this amendment seeks to define diversity for the purposes of the bill. It is a welcome provision of the bill that achieving greater diversity in judicial appointments is a central aim. But we want to ensure that this is not simply lip service and actually has some substance. I drew it from a set of diversity guidelines issued by Brian Lenihan when he was Minister for Children in 2007 and adapted its usage here. I believe the definition is broad and encompasses a wide range of different diverse factors that would be welcome in new judges to be recommended under the bill. It would also ensure that the achievement of diversity could not solely be defined by just moving away from the current cohort with close associations with the current law practice, but would actually be reflective of broader Irish society. I suppose just in my own personal experience, I've spent, I suppose, a lot of time in the courts over the years with clients in relation to addiction. And I know there was one particular judge who she actually passed away in the last couple of years. And I know that my clients at the time really appreciated in her in-depth understanding of addiction. So when they were in front of her for a crime, they definitely didn't feel shamed or stigmatised because of their addiction. And usually her sentencing or how she spoke to them was hugely welcomed by a certain cohort of society. And I think that it just shows that, you know, when we look at a diversity, especially in relation to a class dimension in Ireland, we have to move to a more diverse slate of judges. The position of a judge as a legal arbiter is strengthened when they are reflective of the broader population and given legitimacy as a result. I believe it would only add to public confidence in our judiciary if people felt represented and similar to those charged with interpreting our laws. This can be a positive thing and would be possible if this definition was accepted. Thank you.
Thank you, Senator Ruane.
Senator Ruane.
Okay, where to start? I suppose for the whole length of time that Senator McDowell spoke, it reinforced to me why we need diversity, both on the Commission and in the Judiciary. Whether Senator McDowell opposes the amendment or not, or then tries to stress that he somehow understands my intention, but then continue throughout the whole debate to show, I suppose, a lack of understanding for diversity and also very classist and elitist and protectionism in relation to the judiciary, and it really nearly shows a fear of diversity. And when we look at determining social class, I suppose it's the difference between me and him, and we don't need to, you know, it's very obvious. We have pathways to law now in access programmes, and we have the Trinity Access Programme working with schools in areas of deprivation. You only have to look at a CV to see where somebody went to school. You know, when we look at merit, you know, diversity doesn't impact merit. But when you spoke in the first half of this, you spoke about why the person needs to have this grasp and understanding of the law and how many years they would be in the practice, as if somehow anybody that fell into that bracket of diversity would somehow not meet that. Because for them to be even in the position to be interviewed for such a position, they would be there based on their merit. And diversity is aspirational. It's so that people in the majority, like Senator McDowell, can move over and make the space. Sometimes we just need people to move over and allow the diversity in. And sometimes that needs to be through positive discrimination. And it's not going, what's your socio-economic status, can we see your pay slips? It's very, very clear by the routes that people take through education, the background from which they came from. I might stand in this chamber as a senator and my earnings might be different, but that doesn't change culturally as a class who I am and my experiences and my attitudes. You can have an amazing understanding of the law, you can be an amazing judge, but still have an atrocious attitude to people of a different class from you. And that can be the difference in a judgment. There is unconscious bias. There is definitely unconscious bias in everybody that sits to make a judgment. And it doesn't matter whether they understand the law or not. We only have to look in 2017 at the 60 people locked up for TV licences. And then we have Michael Lowry walk free last week. Don't tell me that there's not unconscious bias when a judge sits in that chair and considers all. After austerity, TV licences and people that got locked up for TV licences peaked to an all-time high, based on austerity, based on poverty. Now, I'm pretty sure if a judge sat there and understood the context, the last thing they would do is lock a woman up for Jobstown for having missed her TV licence payment. There is differences in judgments. Whether we like it or not, there is differences. And whether people set out to do that or not is another thing, but I think we need to be aware of our unconscious bias. I have it, Senator McDowell, you have it. No matter how fair and just we like to be, we all possess unconscious bias, and it does sway how we think, and it does sway how we judge things, and it does give us sometimes a lack of understanding. What it really shows is a difference between attitude and understanding. And like I said, I've come up against many judges, and I probably should stop doing this when I share personal experiences, but sometimes it's only how I can really put the point across. And I remember I stood in Tallaght Court as a child in front of a judge, and I stood there, and he did not care about my situation or what I had experienced or who I was as a person. And all he cared about was standing down and speaking down to me and my father who respects the institutions, who'd never entered a courtroom in his life, who couldn't believe that he was in this situation with his teenage daughter. But all that judge did, he didn't look at the charges, he didn't even read them out. He stood there and he berated my father for who he was, who he thought he was, and who he perceived him to be. And that's the difference when we look at diversity, because we get people that understand that people end up in a legal system on front of a judge for various different reasons, and if anything, it might not change the judgment, because if you break the law and the judgment is there, but it might begin to change how we treat people when they're in the court system, how we view people when they're in the court system, and it might send a clear message to people who are from working class backgrounds, traveller backgrounds, migrant backgrounds, that they can pursue a career in the judiciary, because we're clearly stating in the definition of diversity, in a bill that's supposed to be about diversity, we're clearly stating that we aim to raise our game so that we can create the space for you to pursue your career. And I think whether Senator McDowell opposes the amendment or not, his understanding of diversity and his respect for aiming and being aspirational and being able to create the space, and also knowing that it doesn't mean that somebody else won't get the job because somebody else is from a minority background, because you have to be there based on merit. The merit is the primary focus of this. It is just saying that when we talk about diversity in this bill, that this is an objective. And it might be not an objective right now, because we do need more people in the legal system and studying law to be able to create a diverse judiciary. But what it is it's setting a marker that this is an aim, this is an objective, this is a goal, and it doesn't stop anybody getting in because they're from the majority. And I put in majority for a reason, and it was to not exclude the majority voice, the ruling class, the middle class, from the fact that they are part of diversity of the judiciary, equally to the other people. But right now, they do maintain the space.